We are taking up S278, and we are going to start with Celeste Laramie. She's here. Is that you?
Yep.
How's it going? Thanks for being here.
Thank you. Can I join you at the table? Thank you for having me. My name is Celeste Laramie. I'm an attorney at Bell & Shea in Burlington, Vermont. And I am here on behalf of the Vermont Association of Justice, and here to talk about Vermont's comparative negligence statute. Historically, and still in some jurisdictions, if a jury found a plaintiff to be negligent to any extent, and also found that that plaintiff's own negligence was a cause of their own injuries, the plaintiff couldn't recover any damages. This is a concept in the law called contributory negligence. 12 VSA 1036, which was enacted 34 years ago, changed that law and changed Vermont to a comparative negligence state. And it establishes us as sort of a slightly tweaked, what's called a modified comparative negligence state. And what our statute allows to happen is a plaintiff can recover damages when a plaintiff is found to be responsible for 50% or less of the total causal negligence. And this allows juries to allot liability to the plaintiff and the defendant in proportion to their respective levels of fault. A defendant, therefore, must only pay for that percentage of the plaintiff's damages that a jury finds them to be responsible for. And so, in other words, a plaintiff's damages can get reduced by comparing their responsibility with the defendant's relationship with, the defendant's responsibility with respect to the plaintiff's injuries. A simple example of our comparative negligence rule that I like to use, and it's sort of a classic law school example, is a slip and fall case. You have a landlord who fails to salt the sidewalk in the winter. You have a woman walking on the sidewalk. She slips and falls on an unsalted sidewalk. The woman sues the landlord for her injuries when she slipped and fell. And during the trial, evidence comes out that the woman was wearing, let's say, high stiletto high heels in an ice storm when she fell and sustained her injuries. Our comparative negligence statute here in Vermont would allow the defendant's landlord to argue to the jury that by choosing to wear stilettos in an ice storm, the plaintiff bears some responsibility for and caused, in part, her own injuries. The jury then would get to determine how much responsibility she bears and how much responsibility that the landlord bears. So long as the jury determines that the woman in this example is 50% or less responsible for her injuries, then she can recover for her damages that she suffered, but just reduced by her percentage of responsibility. So in this hypothetical, we can say, for example, that a jury could determine that she's 30% responsible for wearing stiletto heels in an ice storm. If she were hypothetically to be awarded $1 million in damages, to keep the math easy, her damages would then get reduced by 30% to reflect her responsibility by wearing stiletto heels. This would then leave her with a $700,000 damages award. And this law makes sense, right? In the world of negligence, we talk about the reasonable person standard. We expect landlords to act reasonably and salt their sidewalks. Likewise, we expect passersby to act reasonably and wear sensible winter shoes. Where both parties act unreasonably by not salting and by not wearing sensible winter shoes, each party should then bear proportionate responsibility for their own unreasonable decisions. Where the law of comparative negligence does not make sense is in one small area, sexual assault cases. And this is something that I unfortunately discovered with my client here, Zach Blondin, in 2019. By applying comparative negligence to sexual assault cases, we tell sexual assault survivors that they bear some amount of responsibility to predict and therefore prevent their own sexual assault. In 2019, the late Jerry O'Neill and I tried a case on behalf of Zach Blondin, and Zach was one of the Milton High School football players who was sexually assaulted in connection with a perverse hazing ritual that happened in the locker room there, and as well at other locations. I'm proud to sit here today with Zach, and I'm going to let Zach tell you about how Vermont's comparative negligence statute affected him as a sexual assault survivor. So if I could, I'd turn it over to Zach.
That's fine. Thank you.
Thank you.
How's it going?
Good. How are you?
Well, today's the day I've been waiting for. So my name is Zach Blondin. So I've never openly admitted that I'm the kid that it necessarily happened to in a public setting. And so, quick, I guess, backstory is just I grew up local. I mean, I grew up in Milton my whole life pretty much. Didn't stray too far from there since. I was the kid that the Milton hazing thing, I was the victim that had gone through one of them. And so, with that, it kind of created this path that I've now set myself onto where I think everybody's kind of given some form of a situation in their life, everybody has some kind of standing, and I think you're given it because you're the person who's supposed to be able to make the changes with it. I don't think anybody else should ever have to go through what I've gone through in that scenario, nor will they ever if I have anything to say about it. And so with that, I've always taken it kind of let's see what we can do with it. So that's what I'm doing here today. And so when I was 14, I kind of, I went through this really traumatic hazing experience in Milton. And with that, it just kind of I felt almost used as like a pawn instead of the person who was using the situation to benefit others. And so I think it was like 2019, Celeste and Jerry and we had actually taken this to trial. And so with it going to trial, it was a lot. And it was a lot, and I was there for one reason only. I was there to create a principle so that no other school neglected or failed a child to protect a child. Any of your kids, any kid that we ever see, no kid should ever be not protected by the adults around them. And so the reason that I say that is like the school had known what occurred, and the school did everything in their power to avoid making that headline. The school didn't want that bad news with them. And so with that bad news, they did everything that they could to sweep it under the rug, so to say. And so we started to basically tell the story to the jury, and my name was never released to the press just for my own. I didn't want to be known as the kid this is who I am because of this. And so today, Celeste called me about a month ago and was like, hey, so if we're thinking of doing this, what do you think? And I was like, sign me up. I'm ready. I'm ready to admit that, I want to make a change. And I don't care if I have to put my face out there to do it. And so, I mean, the whole situation was very, gruesome, so to say. And really the part that has stretched along and hindered with a lot of this is the fact that they had given me opportunities to settle. And Jerry actually used to chuckle about it because he's like, no matter what they said, you never wanted to settle. Because I was dead set on hearing that the school was at fault, that the school did wrong. Because they did. And I wasn't just going to be an example of, hey, you throw enough money at something and something will go away. And so what we did was I fought it. And Jerry loved it. Jerry used to laugh and be like, I knew you were always going to say, no, I want to hear them say that you guys did wrong. And so when the school did that and the jury came back and they said, we've awarded Zach X amount of money, but then they also found me 40% negligent for my own situation because the first time that I went to this party, I locker boxed one of my fellow teammates. And I don't know if you guys know what locker boxing is. Okay, so you put on lacrosse helmets and gloves and you box. So nobody gets hurt. It's really just, kids being knuckleheads. And so with that, they said that I knew that it was an unsafe area, that I knew that the environment I was going into was extremely unsafe. But I mean, to me, there's quite a difference between locker boxing and sexual assault. And I'm sure you all can agree that, those aren't necessarily the same principles. And so the following week at the same party at the same house, I go through the sexual assault. And so when we're in court, the school's attorney, he just consistently was like, well, you knew it was unsafe. And just kept hindering on that fact that because I had locker boxed the week prior, I should have known I was going to get sexually assaulted the next time. And so what we're here for today is really that's the whole reason that that's even allowed to be an argument, is because they took 40% of my allotted lawsuit away because they found me negligent. And that specific sentence that I heard, I remember I walked out and I just looked at Jerry and I was like, 40%, 40% of this whole thing happened because I attended the party. And it stuck with me. I mean, to the point where I have a tattoo on my hand of 40%, and it's in a specific location for a specific statement. And Judge Store then later recanted this, and she essentially went back and said, you're right. Holding you 40% accountable because you locker box somebody one week and then the next week you were sexually assaulted isn't the same. And so it had been reverted and corrected, but that doesn't change the fact that that was just me. That doesn't change that. Who's to say I was the one person that it worked out for, but the next 15 people don't. And so really with that, I'm here simply because I don't want somebody else to go through that. I'm here because I don't think ever is there a scenario where if you're assaulted, it's because of the shirt you wore or the place you went to. It's irrelevant. Everybody should be able to go anywhere and have a certain level of certainty of safety. And so it's just, we're here simply to help make a change.
And if I can ask you a quick question.
Yeah.
First, I want to say thank you for your willingness to testify to your own experience and for being here to share your story. So thank you for that. My question is, if you're willing to talk about it, I understand the 40% affected the damages, the reward, and would you be willing to share just the mental impact that had on you, maybe regarding your trust of the judiciary system, or just the impact beyond the actual damages?
Yeah. So there was this weird sense of loss because they told me that I did it. We did what we intended to do. But then there was this heavy weight of failure because it's I put myself here. Then I started questioning all of my own doings. Is was I really part of the reason that it even happened? Was it because I should have known better, or that because I did this the week before, I should have known that this time it was going to be? So it really mentally, it was crippling. And I mean, it was crippling because it was falsifying. Like I was told that we did what we came to do, and like I achieved what Jerry and Celeste had always said, like, hey, look, you have this. Like you're going to, we're gonna we're gonna hear the schools at fault, but then by wanting to hear that and getting to hear that, I also was told that I was also part of the reason that it happened, which is wrong. I mean, that did so much to my like mental health. In fact, I mean, Celeste can recall afterwards. there was a few times where I reached out to her and was like, I can't figure this out. I can't keep going. And, like Jerry and Celeste, they walked to the end of the earth and back with me and for me. And so like after everything, like I did more therapy and like, but the damage that it had done really, ironically enough, added to my initial situation because I just felt so like let down. I heard I was also guilty of being irresponsible.
Thank you.
Yeah. Anything else?
Any questions from you folks?
No, I just want to thank you for being here and putting a face to the victims who are told it's their fault that they were victimized, and I'm sorry that happened
And it's
to
not.
you. It's never the victim's fault, and I'm sorry that happened to you.
I thank you guys for the opportunity. Thank you.
Yeah, I just want to add, Zach, that I think it's very brave of you to come forward. It's the right thing to do. I thank you for coming forward, and I'm sure that many victims who may be watching this are also going to thank you for your act here. Thank you.
That was my goal today.
Thank you.
Thank you guys.
So it's my understanding that, was Celeste, were you gonna come back to follow up
I think
or?
just briefly.
Okay.
Hard to follow that. Hard to follow Zach's story, his courage. I understand that you all have a draft of language that had been prepared previously. And I have language here that I would propose differently. And the language that I had seen talks about suing the defendant perpetrator. And the difficulty with that is if we're suing a perpetrator, we're suing them for an intentional tort. We're suing them for sexual assault. We're suing them for battery. We're suing them for assault. And negligence doesn't really enter the equation in an intentional tort. And so it doesn't have the desired effect. And frankly, that the language that as it is presently proposed, I don't know that it would ever get used. And so this language, which I would suggest is an appropriate subsection B to 12 VSA 1036. It says simply, contributory negligence shall be prohibited as a defense to limit any plaintiff's recovery in any action or negligence claim relating to sexual assault. And the reason this matters is it gets to the negligence actions stemming from sexual assault. So in Zach's case, it was a negligent supervision case of suing a high school and saying, you knew better. You knew you had a problem on the football team. You knew you had a problem in the locker room. You knew you had this culture of hazing, and you didn't do anything to stop it. And in fact, a witness testified in Zach's trial that he had seen another boy get sexually assaulted, and that boy unfortunately killed himself months before Zach was assaulted. And that witness testified that the school knew about that, and the school did nothing to take any action, really, to prevent what was a preventable sexual assault to Zach. And so if we just talk about the perpetrators, we're not capturing what happened to Zach. And these negligent supervision, negligent hiring type of cases, we see a lot in institutional cases. We see them in cases against schools. We see them in cases against employers. We see them in cases against religious institutions. So where somebody has a duty to supervise an employee, for instance, or where somebody has a duty to supervise a student, and they breach that duty to supervise that student, and then as a result, somebody is injured, this is where the comparative negligence piece comes in. And so this is what we're trying to carve out, this narrow exception just relating to sexual assault. I'm not suggesting that we apply this to the slip and fall case, for example. I think the public policy reasons are behind this, that sexual assault is different. And, you know, we have, for example, in criminal cases, we have what's called the rape shield statute, where we don't let juries hear about certain things that a victim may have done previously in their past life, or other relationships, for instance, they've been in, because it taints the jury's thinking and it interferes with the evidence before the jury. And likewise, here in Vermont, we have a civil rape shield statute that allows a judge to say, no, you can't put in evidence about that. You can't put in evidence about such and such. And I should fully pass this out to you all so you can look at it.
Did you also submit that? Because I know that the bill needs to be changed as drafted. That information just came to me after the editing deadline. But I would love to, is it submitted to Ben so that we can make it part of the record and incorporate the changes?
We can do that.
Perfect, thank you.
Senator Vio, so you have the vice chair has an amendment
Lovely.
that incorporates that.
So I support this 100%.
Thank you.
Just a few technical things that I want to make sure are figured out beforehand. We're talking about comparative negligence, right? Not contributory.
So it's funny when I look at the statute, it is confusing because the statute itself is called comparative negligence, but the very first two words of our statute as it's currently drafted say contributory negligence. I think it's a reflection of sort of the crossover that we have here in Vermont as a modified comparative negligence state. So we are still, I think, technically a contributory negligence state in as much as you're over 50%.
Yeah.
Because if a plaintiff is found 51% responsible in the slip and fall case, for instance, that bars a recovery altogether. And so I think we could call this statute comparative negligence and then also use the comparative negligence language throughout the statute, but that's above my pay grade. I think we can still fairly call it contributory negligence because there is still a provision here that would allow a total bar if a plaintiff were found to be 51% or above responsible.
Thank you. And just because I like to be prepared, do you have any thoughts or input about what potential pushback there could be regarding this type of change?
It's hard because I'm pretty biased. The good news is that there's still a liability determination that needs to be made, right? If we take, for instance, the school, if we had never proven that the school had notice that there had been previous sexual assaults that should have made Zach's sexual assault foreseeable, then the jury could have just found against Zach, and that was the end of the inquiry. So there's still a threshold finding of negligence. You still have to, we as plaintiff lawyers still have to prove that the school owed a duty to Zach, and the way we would prove that is that it was foreseeable. And so once you get over that initial hump of, okay, so there's liability here, so what? What are the damages? And so you still have the gatekeeping function of that. In theory, to the extent that institutions ever engage in talking about consent, I mean, it's a dangerous road to go down for institutions to say that Zach had consented, for instance, to what happened to him. But to the extent that an institution has a fact pattern that warrants consent, they're free to still argue consent. And they're still free to put in evidence that they didn't have a duty, that the thing wasn't foreseeable. And the judge still gets their gatekeeper function of, you know, this evidence can come in, that evidence can't. But what this would do is prevent defense attorneys from, once a liability determination has been made, then reducing the damages to displace blame. Because once liability has been found, it's 100% blame in the equation, I think, as it relates to sexual assault, because if it's a sexual assault, you're not consenting. Right?
Thank you.
One quick question, thank you. I'm not an attorney. So either you or Michelle's gonna have to walk me through this process somewhat, but it's not a large question. When it comes to this civil action, is it generally something that takes place after criminal court? And if so, I realize this is based on a preponderance of an evidence. So even if someone is found, say, not guilty in criminal court, is this something that still has strong bearing moving forward in civil court with a 51% threshold?
So, yeah, criminal court and civil court are two totally different lands. Typically, civil cases, well, let's take a criminal action and then let's take the companion civil action. Typically, civil actions often get stayed during the pendency of a criminal case because the defendant has a Fifth Amendment right not to testify. And so what often happens is, for instance, a plaintiff lawyer would file a civil suit to preserve the statute of limitations, so that wouldn't run. But then it's a corollary, and as a plaintiff's lawyer, I love getting cases where there's already been found a guilty finding in criminal court, because that's already a higher standard that they found a defendant guilty as opposed to being responsible. So they can be parallel paths. They're often not happening at the same time, but it's a totally different standard, the preponderance versus the beyond reasonable doubt. And in a criminal, this would have no bearing on a criminal action because there's still the preponderance of the evidence. The defendant can still argue that, for instance, Zach had consented if the actual perpetrators were being charged in that instance. I'm not sure if I answered your question.
Well, I just wondering the strength of this is to retrieve damages, obviously. I'm just wondering about the strength of this bill as far as it moving forward. If in fact someone is found not guilty in criminal court, is this something that still is going to benefit?
It could civil cases get brought when plaintiff's lawyers are willing to take them, right? Unless somebody decides to take it themselves. I think civil lawyers are going to look very closely at a case where somebody's been acquitted in criminal court, because they are going to recognize that in criminal court, somebody found enough evidence, well, the jury found enough evidence to find that the defendant didn't do this at all. And so that's a high bar, a big hurdle to have to overcome in the civil case. And I would have a difficult time taking probably a case like that as a civil lawyer.
Okay, thank you.
That helps.
I got some of a grasp on it.
All right, not seeing any other questions. Thank you.
Thank you.
So, next up we have Kara or Cara?
Kara.
Kara, thank you.
Thank you. So my name is Kara Casey. I am the Director of Economic Empowerment at the Vermont Network. You usually hear from one of my colleagues, but I've been tagged in today. So we strongly support this bill. Defendants should be prohibited from attributing any blame on victims of sexual assault in civil actions. As a matter of criminal law, as you heard, a sexual assault defendant cannot introduce evidence that seeks to blame the alleged victim, thereby saying that it is the alleged victim's fault. Under the criminal rape shield statute, criminal defendants may not, for instance, introduce evidence of an alleged victim's prior sexual history, with some limited exceptions. In the civil justice context, where a victim of sexual assault seeks damages from the assailant and other culpable parties, current Vermont civil justice law allows a defendant to blame the victim for their sexual assault. Vermont's civil rape shield law bars the introduction of certain evidence about a survivor's past sexual conduct. However, the comparative negligence statute, as you just heard about, allows a defendant to argue that a survivor is partially at fault for their own assault. This leaves the door wide open to a defendant being able to argue to a jury to blame the survivor and reduce the survivor's damages award in proportion to how much responsibility the jury determines that the victim bears for their own sexual assault. For instance, a jury might determine that a victim should be awarded $100,000 in damages for their sexual assault. However, because the victim chose to wear certain clothing or drink the night of the assault, a jury could reduce the damages award to, let's say, $60,000. Victims of sexual assault should not be held responsible in any way for the violence inflicted upon them, and we would urge you to pass this bill.
Thank you.
Questions?
My question, have you seen the proposed changes?
I have not. From just hearing them, it sounded like something that we would support, though.
Okay, I assumed that that would be the case, but it would be great to just get it sort of on the record that you also give that a thumbs up.
Yes, I would say that we would support that.
Okay, thank you.
I think
I don't know if I have the proposed changes.
This, oops, there we go.
And these are proposed by,
This was proposed by the attorney who tried the case that brought this to us,
Yeah,
but we
this
have an
was-
amendment that
yeah,
Michelle's gonna
I-
pass out as well
we can post
that
it.
incorporates this
The
language.
draft that you sent me with comparative negligence.
It's okay.
oh, you have one, okay.
She can prepare.
Oh, they shouldn't be stapled.
I just
We
stapled
just,
them, but
you weren't in the
that was
room,
not
but we
my fault.
discovered
It's one for
basically a
everybody.
drafting error that
Okay,
you
sorry.
wanted
Okay,
it to be, but
okay,
after
gotcha.
the editing deadline, and this
Got it.
solves that.
Stand by. One moment. So we have new language from Michelle, from Ledge Council, that I thought was just one stack of paperwork for me.
Ah.
See what happens when I don't let Ben control the handouts?
So the draft language includes, well, changes the first, well, actually, we're about to have Michelle, so maybe Michelle can do the walkthrough.
It matches up pretty closely with what was proposed.
Yeah.
Celeste, do you want a copy of this? I'd be happy to look at
And
it.
I think Ben will have
Yeah,
it up on our website as well.
Yes.
Appreciate it. So, good morning, for the record, Michelle Childs, Office of Legislative Counsel. And so what you have is a strikeout amendment to S-278 that does just what I think what the witness Celeste talked to you about. I think, so you'll see there's a section 1, it's still amending Title 12, so you're in the court procedure title, 1036. So the issue around comparative contributory negligence, she did a great job talking about the distinction between those two. We went back and looked at the legislative history for the statute to kind of, because, so while I work with you on the domestic and sexual violence laws, I typically don't do the civil litigation stuff. Eric does that. And so for me, kind of looking at that, it was very confusing to see the two terms used in the same statute. And so I think, you know, what I did for clarity, because those are two different things, even though we talk about it's a modified comparative state, is that I just changed the reference to contributory negligence on line 9 to comparative. I don't really have a strong opinion on that. I think, you know, that's probably up to the practitioners about whether or not you know, you need to make that change. To me, it seems a little more consistent, but that's a policy decision for you based on your testimony. And then you look at, there's a new subsection B on page 2 on the back. So simply saying that comparative negligence is prohibited as a defense to limit the plaintiff's recovery for damages in an action for negligence claim relating to sexual assault. The effective date would be this July 1st. I did add a new title to the bill because it was referring to contributory negligence and the bill was introduced. I think also Kara talked to you a little bit about the criminal law rape shield laws. I sent you a link in your emails to that, just if you kind of want to look at what we have currently under law for criminal cases. I also sent you a link to the Vermont Supreme Court case regarding the state law case.
Thank you, Michelle. I have one question. Just want to avoid unintended consequences. So, so we're prohibiting comparative negligence with this language. And is there anything to stop the defense attorney from saying, all right, comparative negligence is prohibited. However, contributory negligence is not mentioned, so I can raise it as a defense? Or is it somewhere else in statute that contributory negligence is not allowed?
I believe that this is it.
Okay, thank you.
maybe this is a question for you, Michelle, maybe it's a question for someone who's not in the room, but is there a reason for this bill to take effect on July 1st and not on passage?
No, that's typically our default. So I think policy decision for you, you just want to be thinking about, when you enact a new law, right? You got to get everybody else up to speed, right? So typically when we are creating new criminal laws or things that the court's going to need some time to do training on, or practitioners going to need to do training on, you want to think about giving them a little bit of lead time. This may not be one of those cases. It may be fine upon passage, but again, kind of check in with people who are going to be practicing in this particular area, whether or not they see any drawback to doing it upon passage.
Just a quick question. I don't know if this is for you or for Webster, but contributory versus comparative, the definition of the two, is there a large discrepancy in those, or?
Yeah.
Yes, in terms of, and I think that if you look at the testimony, I think that's a great cheat sheet that she gave you in talking about what Vermont has with regard to, so if you are contributory, then you're essentially, if you are if you are found at fault in some way, then it's barring you from recovery. So it's kind of like if they find that you have contributed in any way, then they bar you from that. If it's comparative, then they do a balancing test. And as long as you are not more than 50% at fault or negligent.
So the stilettos come in with the contributory comparatives.
Right, so if you were, right, exactly. So if you wore the stilettos, they'd say, nope, you're out. You shouldn't have been wearing those shoes.
But I do want to be clear that this bill wouldn't impact the stiletto case because this bill only applies to sexual assault.
Correct, right.
So you would still
Yes.
be able to decrease someone's award for the slip and fall in stilettos, even if we pass this.
Right. So one thing I will just raise as an issue, don't mean to complicate it, but so using the term sexual assault in Title 12. So, if you're thinking about, well, do you want to limit it to sexual assault, and what does sexual assault mean in this context, right? And so we have definitions under, Chapter 72 of Title 13 around what constitutes criminal sexual assault, but then there are also a lot of other types of sexual offenses. And so I just kind of raise that, and I don't know whether or not the witnesses have an opinion on that. I know this is the language that they offered, and it's very specific to this case, but I just kind of introduced that because, there are instances of things that might not qualify technically as a sexual assault under Title 13. Do you want to think about maybe having any more specificity with that? And it may not be necessary in this civil context.
So would lewd and lascivious be swept
That's kind
up
of what
under
I'm
this?
thinking of, things around, like an LNL, with something that might qualify as an LNL with a child under Title 13, would it be considered as sexual assault under here? It may be, and this may be fine. I just kind of raise it as something to consider, and making sure that we capture your intent in the language, and so that it's clear.
Helpful.
That's good to know.
Celeste, do you have an opinion?
I agree, I think you're right. I think
We should expand that
I
language.
think if it doesn't explicitly say lewd and lascivious, then what that allows is, well, it requires the judge to make a decision whether your intent was to include a lewd and lascivious under sexual assault, and so this would eliminate the ambiguity around that issue if we were to cast a wider net.
So would that be utilizing, rather than sexual assault, sexual offense?
But then I think that it invites more vagueness there. I mean, what I can do is, and we work with these statutes a lot, is give you kind of like a short list and a reference, and you can kind of pick and choose, and then I can craft the language for you on the type of conduct that you want to encompass.
Okay.
Yeah, no, I agree. I think there should be a way to sweep in any offense of a sexual nature. So, whatever that language looks like, or if we have to, list each crime.
There's a lot. I mean, because,
right.
if you're talking, there's the
Aggravated, lewd and lascivious.
Well, there's those, but then you also, I mean, if you think about, would you want to extend it around things, like, child sexual abuse, production of child sexual abuse materials, or, like those types of things? So when you I mentioned that because when you say sexual offenses, there's a lot, you have your chapter on lewd lascivious, you have your sexual assaults, you have your ones with regard to sexual exploitation of children. So there's a lot of different offenses, but we can craft it however you want. I can make a little list for you.
I'm always hesitant to make lists because in my experience, when we make lists, we inevitably leave things off the list that shouldn't be left off the list. And so I want to try to think of language that incorporates what we want to incorporate without explicitly making a list, because I am certain, just in my 3 years in the building, that if we make that list, we're going to be back here in 2 years being like, oh, we definitely meant to include that and not blame people for that happening to them. And the damage that is done when a victim is blamed for their sexual assault is so incredible that I don't want to have someone damaged the way Mr. Blondin was because we forgot to put something on a list.
And I can work with the witness on
Okay.
trying to come up with something. We just don't want to leave it so vague as to having to have the court kind of discern what it is that you meant.
And I think the other distinguishing piece is, as we established, big difference between criminal and civil court, and the offenses, the charged offenses that you see in criminal court aren't necessarily titled the same as what you'll see
Correct.
in civil court. So I think trying to figure out how to fix the language so that it encompasses what is being brought up in civil court rather than criminal court is what we have to figure out.
Mm-hmm.
I
I
personally,
can also consult with Eric a little bit, because he's worked on all of the civil stuff with regard to the timelines with regard to the sexual abuse cases involving children.
I personally would like a list. It gives me a jumping point, a starting point.
Sure.
That we can do it with after the fact.
Yes.
Just
No worries.
The only other thing that I just want to make a case for is changing the effective date to on passage. And the reason I feel that way is that the damage that can be done between now and July 1st seems significant enough to me that we should enact this as soon as possible. One person in between now and July being told that it's their fault they were assaulted seems like one person too many, not to advocate that this be in effect on passage.
I take the point. I guess back to what Michelle said, I'm wondering about people who are in process. I don't know if anybody is, but a defense has been constructed and is going to be put forward. It's already playing out in the court system, and then we pass this. If it's immediately, if it takes immediate effect, it really disadvantages one party in that ongoing dispute. Whereas if it's, 3 months from when the governor signs it, we at least have the argument that there was advance notice. I just worry whenever we say that something will take effect on passage, where you have contested parties, or somebody can claim that they're disadvantaged by the new law and generate lawsuits about the law itself. And I think we can avoid that with the July date. But that's just my inclination. I'm happy to discuss it or.
Yeah, my response to that, my first reaction is, this wouldn't affect in my opinion, the defense that's being made to establish liability. Rather, it changes that final endpoint when the jury is deciding, all right, how much money should this victim get?
Mhm.
And are we going to reduce it by 40%, or do they get what we've decided based on the evidence that's been presented?
Mhm.
So I don't know that, maybe we could speak with a defense attorney, but I don't see how it would affect the defense strategy in proving liability or disproving liability.
And I'm happy to be proven wrong on it. I just feel if we're because it wouldn't become, you know, something that people could act on until the governor signed it. So it would be up in the air until that moment. I'm just thinking, should there be a case that was in process? Is it, and we've been through this before with other laws where we're impacting ongoing cases or legislation. So I'm just saying the default is usually to put it out of bounds for that reason. If in this case we decide that, as you say, the possible consequences of it are not worth it, and we want to make it immediate, I just think it's a discussion we have.
And we can look, there are statutes that address kind of when you do enact things, the general law of applicability, but we can be very specific here with regard to how that's addressed. But it's a great issue. It's a great point, so.
I tend to agree with Senator Cruz on this one here. I think that if in fact the very unfortunate act has already taken place, I'm sure that any attorneys looking at civil would be more than willing to at least wait until after that July 1st deadline to file their case. Doesn't make it right what's happened or transpired prior to that. But it's open for negotiation. Okay, that's how we deal.
So I've gathered that the two main discussion points for this are the effective date and language that encompasses all civil offenses of a sexual nature. Those are the two main points that we have to figure out.
Sounds about right.
Seems so.
Great. Any other questions, or, I mean, we've got plenty of time until we adjourn. We can talk about it a bit more, or we can adjourn early.
Have we ever had the effective date being an issue before?
Oh, yeah.
Oh, yeah. Okay, see.
Well, then you get
Yes.
into retroactive. and
Yes, how to apply things that are in.
We just want to do
Right.
what we feel is right, obviously,
Yeah.
for victims of that.
It's one of those things we oftentimes don't think about because it's.
Well, the
and
first
then-
bill I ever reported, you know, you get hazed, or at least traditionally you got hazed. And so I studied everything, and Vince Belluzzi stands up on the floor, and all he talks about is the effective date, which I hadn't even noticed, and he just took me completely apart on the effective date for about a half an hour. So I have never not looked at a bill in terms of the effective date since then.
I think we all learn those hard lessons. I learned a lesson this session about making sure the title of the bill aligns with what you want the bill to do. Senator Hashim, I'm happy to discuss more. I'm happy to adjourn early. I don't know what
Anything else
is the
to do?
will of the committee. I feel pretty strong
All right,
about
good.
the effective date.
All right, we can adjourn. Thank you, Michelle, and thank you to all the witnesses.